What's going on, everybody? This is Lady Luck. Okay, this video is for my members only. Want to thank you all for supporting me here in the LLC, supporting the channel, broadcasting from the $400 studio, which I am very, very proud of and blessed because of supporters like you all who have helped to ensure that some of the equipment was either ordered and purchased from Amazon, or you blessed me with Amazon gift cards, to ensure that we have great equipment like this mic and like the light, the internet, of course, StreamYard, the chair, the desk, all these things because you all took the time to support and be a blessing to this channel and to this platform. And I cannot thank you all enough. I have a court case I want to go over, and I titled the video what I have it as because I want to come up with something a little clever. I just haven't hit the nail with the hammer yet. So maybe y'all can leave me some ideas in the chat, in the comment section, of what the title of this video should be. That kind of, it has a better ring to it. But this is for the members, to the LLC freebies and to the LLC readers. I thank you all so much for supporting the channel. I told you all that I was going to be reporting on some really good stuff here that I am not going to make available to the public because you all deserve the goodies. All right. So I'm going to put some music on. I like to have this in the background. So before I begin, I just want to make this known. I read and research and report on court documents because I enjoy reading them. I do. It is rare that I come across a court document or, a case that's being handled by a judge where I actually have a connection to that person. It is so rare. That's what blew me away with this one. And that's why I wanted to report on this. I haven't read all of the documents out because I'm reading this stuff in real time. So my reaction to this stuff is in real time here. But I just kind of skimmed through it, saw, what the case, the parties of the case and the judge that handled the case. And I was like, oh, I got to read this. I got to read this. So we're going to dive into it a little bit. We're going to get started on it. What I'm going to do is just highlight the documents itself. There you go. Make myself small and make the documents huge. So, y'all, this is case number 20-CV-05185-LMM, U.S. District Court for the Northern District of Georgia, Atlanta Division. Jedidiah Brown versus Jackson Protection Agency, LLC, and Partners for Home, Inc. There was a demand for a jury trial on this. This is a pretty old case. This is going back to 2020, at least when the initial filing was done, 3 days before Christmas. Look at that, 12/22/2020. It's 11 pages. This is the complaint. I do have a few other documents related to the case docket that I want to go over. Before we get into the case, though, you guys see the defendants here. I definitely want to bring up some information on the actual company itself. So let me go ahead and share the screen so we can kind of get some background on this Jackson Protection Agency, because I did look it up. All right, so this is the Jackson Protection Agency. I'm assuming it's based here in Atlanta. I never heard of them. And this is the company that Jedidiah sued. They offer services such as travel security, executive protection, K9, and more. Let's see here. JPA is a veteran-owned and operated organization headquartered in Atlanta, Georgia, with the intent on providing security while upholding the standards, codes, and ethics Along with providing security work, we strive to educate and enrich the general public along the way. We are blessed to be operating in 10 different states all over the US. We plan continued growth and development projects in even more major cities for the upcoming year. I don't know when this was updated or anything, so I don't know what year they're referring to, but yeah. JPA prides itself on being an industry standard for the future with a global impact. JPA is committed to excellence and will always take time to help a stranger in need. We have a wide range of services and offer a series of basic classes both in person and online. Click below to find out more about the team and their vision. Okay, so let's find out about the team. It's, I mean, do they have the team? So they're basically a hired security detail that you could have for certain events. Let's see here. They did say events, K9, travel, assets, training, and they say veteran owned. I mean, I haven't looked into this to see what kind of credentials they have. Um, these are their partnerships, I assume. Partners for Home, City of Atlanta. I've never heard of them. I've never heard of them. Atlanta Community Food Bank, Safe House, House of Hope, Mentoring Exception, Hope Atlanta, Umi Feeds, Hope Through Soap. So these are some of the partners. I've never heard of them with the City of Atlanta, but I'm not saying they don't. I've never heard of them. Let's see, blog. Where's the team? I'm assuming that these are all the people that are in the company here, volunteering. I would like to see like information on the team itself. Like maybe the founder. Who's the founder? Who's president? Who does what? Let me see. Why us? Oh God, it's taking me. I'm not doing that. Okay. You know what sucks is that you can't see who, you know, it just says book now, but it doesn't give you like the employees there, at least the CEO or the president or somebody, and uh the faces of the people that are going to be doing the security detail. They got this here, but I guess that's it. That's it. That's all you get. Okay. All right, so that is the company in a nutshell. Not a whole lot on the website. Doesn't really tell me much of anything. I don't know if I actually am happy with their advertisement like that. It's just not a whole lot to go on. So yeah, I would kind of, I mean, if you try to use something like that, more than likely it would be kind of like I would want to at least be able to see who the CEO. It doesn't seem like a huge company, but tell us who the CEO and or the president, vice president of the company is, or something. But as you all can see it, yeah. I don't know if the company is still up. I mean, it could be shut down. I don't know. But yeah, that was the website. All right, so let's get to the complaint here. This is the good stuff I want to get to. So now that we all know the JPA, I didn't look up Partners for Home, but you guys saw that was one of the sub, I guess, companies, one of the partners that they have with them listed on the website, along with like City of Atlanta, House of Hope. So Partners for Home was kind of one of those partners they have. This was a demand for jury trial. I don't know what he sued them for, so we'll find out. Comes now, plaintiff Jedidiah Brown and submits this complaint showing the courts as follows. This is a case arising out of defendant's employment discrimination and retaliation against plaintiff in violation of Title 7 of the Civil Rights Act of 1964 as amended, 42 USC, Statute 2000E, etc. Jurisdiction and venue. Plaintiff's claims present federal questions over which this court has jurisdiction pursuant to Plaintiff's claims present federal questions over which this court has jurisdiction pursuant to 28 USC Statute 1331, 1343 sub A, and 42 USC 2000 E 5 F3. So those are just the federal laws that's being cited here. Venue is proper in this court pursuant to those federal statutes, as he claimed the currency incident itself occurred in the Atlanta division, which would fall under, being that this is a federal lawsuit, would fall under the U.S. District Court for the Northern District of Georgia. Plaintiff satisfied all conditions precedent to filing this action, including filing charges of discrimination with the U.S. Equal Employment Opportunity Commission and receiving notices of right to sue within 90 days of filing the civil action. So when you have a discrimination claim against your employer, the state law requires here in Georgia that you file a complaint with EEO, and that being the Equal Employment Opportunity. They do an investigation. If they see, they sometimes they will deny, or they will say, well, we will not pursue this further because we have not found any evidence of discrimination. But if they do, what they'll do is to send you a notice to, where you have the right to sue based on that discrimination claim. And then oftentimes they try to call and contact the employer, see what's going on, work things out. And if the employer decides, they tell them to take us to court and then they send you the notice of the right to sue. And at that point, moving forward, you're lawfully required to at least allow the EEO to get the complaint first, and then they send you the notice, and then you can go ahead and file the lawsuit. So I've never had a matter go through that full process. I don't know if EEO provided him with an attorney or if he still had to hire his own attorney. But I do know they will do a preliminary investigation. So for the parties, plaintiff is an African-American male citizen of the U.S. and a resident in the state of Georgia. Plaintiff identifies as bisexual. Plaintiff is an outspoken and well-known advocate for racial justice. Defendant Jackson Protection Agency, LLC, hereinafter is named as JPA. So we're going to utilize the acronym. It's a domestic LLC. It provides security services to clients. JPA was registered with the Georgia Secretary of State to conduct business in the state of Georgia at all times relevant to the allegations in this complaint. So it will basically functioning as a company and organization in the state of Georgia. Let's see. I just want to make sure everybody can see. Okay. JPA may be served with process upon its registered agent, Brandon Shea Jackson, at 1740 Hudson Bridge Road, Stockbridge. And I'm assuming that is a company business address. And if it's registered with the Secretary of State, then, I'm sure there's a license and everything on file. At all times relevant to plaintiff's claims, JPA employed 15 or more employees. JPA is an employer and or joint employer under Title VII at all times pertinent to this action and was plaintiff's employer pursuant to the statute. Defendant Partners for Home, Inc., hereinafter PFH, and that's what we're going to refer to it as throughout the rest of the complaint. It's a domestic nonprofit corporation that partners with other nonprofits, government, and business leaders in order to provide guidance and shelter for the homeless population in Atlanta, Georgia. PFH was registered with the Georgia Secretary of State to conduct business in the state of Georgia at all times relevant to the allegations in this complaint. PFH may be served with the process upon his registered agent, Catherine Marchman, at 55 Trinity Avenue, Atlanta 30303, which is a business address, because I know exactly where that is. At all times relevant to plaintiff's claims, upon info and belief, PFH employed 15 or more employees. Let me turn on the sound just a little bit more. Okay. Sorry about that, y'all. The music just seems a little loud in my ear. PFH is an employer and or joint employer under Title VII at all times pertinent to this action and was plaintiff's employer pursuant to the statute. Factual allegations. So here's where we get to the background facts of the case. For all times relevant to the lawsuit, PFH contracted with JPA to provide security services at 2 Atlanta area hotels housing homeless individuals. Paragraph 9, in or around April 2020, JPA hired plaintiff as a security officer, and he was promoted to supervisory security officer shortly thereafter. Okay, so he went in as a security officer and he was promoted supervisory security officer. Okay, cool. Plaintiff was assigned to manage JPA security operations at 2 Atlanta area hotels housing homeless individuals under its contract with PFH. So PFH was a contracted nonprofit that did business with JPA. And yet so it sounds like he was hired through PFH. Because I don't oftentimes see it the other way around. I told you I haven't read this. So it seems like he was hired under PFH if he's working with the homeless here. All right, let me just keep reading. He was assigned to manage JPA security operations at 2 Atlanta area hotels housing homeless individuals under its contract with PFH. Okay, there you go. So, I mean, being promoted to supervisor, more than likely he was just over some staff and they were just assigned to that site with the hotels housing homeless individuals. What are those hotels? What's the name of them 2 hotels? It says 2 Atlanta area hotels housing homeless individuals. What's them hotels? While working at the 2 hotels as supervisory security officer, PFH exercised control over plaintiff's terms and conditions of employment. Okay, so he was hired through PFH, and then of course they basically got a contract with JPA, and basically JPA was just more of the contractor or the client, where PFH was the contractor. I hope I'm understanding that right. JPA contracted with PFH, say, hey, we want you all to, service these 2 Atlanta hotels, since you all deal with, a homeless population. We can work together to get security at whatever sites that PFH has under their umbrella when it comes to servicing the homeless community. Got it. All right, because I wanted to make sure I understood this whole employment thing, because that's going to play a big role in how this lawsuit is played out in the rest of the documents here. Because if he wasn't a direct employee of JPA, and I think the lawsuit should have been more so just PFH, but okay, let's keep reading. Okay, so for example, PFH directed plaintiff's work at the hotels. Right. Plaintiff attended daily meetings led by PFH supervisors. Plaintiff was responsible for adhering to PFH employment standards, and PFH disciplined security officers and supervisors. So he was sounds like he was a direct employee of PFH, and PFH just got a contract with JPA. And they were fulfilling a contractual agreement with JPA. That's what it sounds like. I could be wrong. All right. So the PFH directed plaintiff's work at the hotels. So they basically gave him the job description. If he needed to be disciplined, it would come through PFH. The employment standards, he had to adhere to what PFH had in place. Meetings. Question is, are they the ones that, paid him his paycheck? How did that go? Plaintiff soon realized that defendants maintained a culture of discrimination and retaliation against hotel residents and defendants' employees. I would love to know those 2 hotels. I would love to know that. Just for knowledge sake. And know what those 2 hotels are that are predominantly for homeless individuals, because this is in 2020. There are a couple of places where the homeless could go downtown Atlanta, near it used to be well, now it's Midtown, Emory Midtown Hospital, but there was a couple. I know there was one shelter across the street from the hospital where people could go. That was shut down a while ago, so I'm not quite sure what these two hotels are, but man, would I love to know. So, all right, let's keep reading. Ooh. For example, JPA's operation manager told plaintiff to find a pretextual reason to justify the termination of two gay security officers. To find a pretextual reason to justify the termination of two gay security officers. Why would JPA's operation manager tell him to do that? It doesn't make any sense. If JPA is the client here and they just contracted with them, why would JPA's OM call him to ask him to justify? That makes no sense. All right. Plaintiff regularly advocated against defendants' unfair treatment of residents and employees. Plaintiff brought complaints directly to supervisors and officers of defendants of PFH, from what I'm reading up here. Because led by PFH supervisors, he was responsible for adhering to PFH employment standards, PFH discipline security officers, and supervisors. Once again, why would JPA's operation manager tell him to find a pretextual reason to justify terminating two gay security officers? Of all the people in JPA, in the company, which is contracting with PFH, do they not have some sort of an employee labor relations division or a legal and compliance department? I mean, what the hell? That didn't make any sense. Y'all, when I'm reading this stuff, I'm trying to make sense of this. It makes no sense. Good grief. Oh, okay. What the hell? All right. So he regularly advocated against defendants' unfair treatment. Got that in. Plaintiff brought complaints directly to supervisors and officers of defendants. On or around May 20, 2020, JPA CEO Ronnie Jackson and CFO Shea Jackson. It's the only way I knew who the CEO was, reading the court documents, because as you all can see, I didn't see none of that shit on their website. JPA, your website sucks. If it's still up, if you're still a thing, your website sucks. At least have a picture of all the people that are sitting in the corporate branch. That would be like the CEO, the CFO, the CMO, treasurer, you know. If you have a board of trustees, like, you know, those people, you don't have to list every single employee, but at least the ones that would be considered corporate. What the hell? No one knows who you people are. You can't expect business. And no one knows who you are. We don't even, this is my first time hearing the CEO's name. It's not even on your own website. Good grief. 5 years later, I just looked up the website and we still did not see anything about any corporate structure on their website. Nothing. So weird. I'm just pointing it out because that's, you know, you operating in multiple states across the country and you don't have anything up there about your corporate structure, your corporate office, or the corporate headquarters. We got to look at a lawsuit or find your business license for that. Come on now. Do better. Do better. Do better, JPA. All right. So JPA's CEO is Ronnie Jackson, and now I can look him up later because who the hell is that? Who is that? And CFO Shea Jackson told plaintiff of a rumor, it sounds like husband and wife or something, of a rumor that plaintiff had a sexual relationship with a male resident. They asked plaintiff if he was gay, which they cannot ask. What the hell? What did I just read? Start over. On or around May 20, 2020, JPA CEO Ronnie Jackson and CFO Shea Jackson told plaintiff Jedidiah Brown of a rumor that plaintiff Jedidiah Brown had a sexual relationship with a male resident that was homeless in the homeless hotel. in the homeless hotel. The two Atlanta homeless hotels he was the supervisor of. Yeah. Two Atlanta area hotels housing homeless individuals under its contract with PFH. They were contracted. Why is JPA going to their vendor employee about something? Why isn't the CEO of PFH not going? Who was this? Was PFH Jedidiah's business? And he just had another registered agent? I don't even understand, why was JPA going to him directly about anything? You want him to find a pretextual reason to justify the termination of two gay security officers, where you should have been going to, unless he is the owner of PFH, or he's kind of, I don't know. It says here he's a security officer. I mean, supervisor. He was a supervisory security officer. So why would a vendor, a contractor, or client, however you want to put it, JPA and PFH client, they're working together through a contract. Why would JPA go to a vendor employee who's just the supervisor of the security officers, as opposed to PFH owner, CEO, or whomever, and talk to their employee? This is so weird. And then paragraph 16 is blowing my mind. It's blowing my mind. So, plaintiff brought complaints directly to supervisors and officers of defendants. That means his complaint should have been going to PFH. He was employed through PFH, not JPA. JPA was just contracting with PFH. Why would they go to a supervisor of the security officers and not whoever is the corporate structure of PFH? That makes no sense. It just, I'm gonna be honest, it just seems messy when they're doing something like that. There's a chain of command to go through here, people. JPA, there's a whole ass, hopefully there's a whole ass chain of command for PFH. I'm gonna look that company up, because I have questions. And it's just, it's not making sense. Let me go back to the website, this garbage website here that has nothing here. This doesn't make any sense to me. Am I the only one confused? I'm gonna hold on. Let's share this again, because this doesn't make any sense to me. Okay. Partners for Home. Isn't that the... Yeah, PFH is Partners for Home as the one of the defendants. So he sued his company he worked for, as well as the vendor or the contractor that they contracted with, because PFH focus was more on the homeless population and helping organizations dealing with the homeless population. JPA is just the security service, bodyguard type stuff, right? So I'm baffled as to why. I'm gonna tell you why I'm stuck on this, because you don't see that happening when it comes to working with a contractor or vendor. If the city of Atlanta, contracts with a vendor, the city of Atlanta's manager is not gonna call a supervisor that is employed through the vendor talking about pretextualize a reason to justify the termination of someone. JPA should not care who PFH hires or fires. And JPA, if they're terminating someone in their company that has nothing to do with PFH, then why are they asking a vendor's employee to justify that? Does it make sense? That makes no sense. Am I not confused here? God. Partners for Home. This is one of their partnerships. Hold on. Because now I'm going to share. I'm going to Partners for Home. Oh, good God in heaven. About, okay, response, performance. Yeah, this is Partners for Home. This is PFH, to whom Jedidiah is working directly through. So I'm assuming PFH is the one that gave him his paycheck. So they deal a lot with the homeless and have, provided assistance for the homeless population, which is, I mean, if done right, could be a blessing, really. Um, Call 311 to get help. So this is primarily Atlanta based, from what I'm seeing here. I'm always wanting to see, who's at least the corporate structure. Put a face to a name. If you're the CEO or the president of something, put a face to a name. Put a face to a name. Unless you have like a YouTube channel and you just never show your face, but put a face to a name. This is a whole company. You got a website up and everything. Let me see if they have who's on the contact. So they have these separate websites for other partners they utilize: Gateway Center, Mercy Care, Atlanta PAD. I'm still trying to find, like, let me see, advocacy. Since he's an advocate, let me see. I'm not seeing any like structure here. Like, who's the hierarchy? I'm gonna tell y'all right now, I'm not trying to dive deep into the company itself. I'm just curious to know who the higher ups are, because I cannot I can't understand why the higher ups would allow a vendor, someone they're contracted with, to notify one of their employees to justify the termination of 2 gay security officers. Why would they not go to their own legal department for that? It just seems shysty all around. All right, let's get back to the filing. That's why we're here. Let's get back to the filing. Oh man, this is something else. You know what I'm gonna do? I'm gonna let this live stream, and then give people first chance to watch it, because I maybe someone out there has questions that may or may not be members. I don't understand. I don't understand. I don't understand. Okay, let's get back to the court doc. Let's get back to the court doc. Now y'all see why I love reading court docs, because there'll be some stuff in there. That's the only reason why I'm coming across this. This is simply because y'all will see. You'll see. You'll see. Okay. Let me make this a little bigger. There we go. Let's get back to it. This is good stuff. I have a few more documents too. Okay, we were on paragraph 16, because I'm going to read it again. On or around May 20, 2020, JPA's CEO, Ronnie Jackson, who did not go to PFH's CEO or VP or anybody, and CFO, who's the chief financial officer. Why is the chief financial officer going anything about something that sounds like an employee labor relations type of issue? What does the CFO, unless it happened to her? I mean, it's not a employee in the finance department. So why is the CFO going about doing anything that's a matter of either legal, compliance, employee relations, HR situation? Why is the CFO involving herself in that? And trust me, we're gonna get to the next point in this paragraph here, but that right there, if you're gonna run a business, run it right. When you think you want an attorney and a compliance, the HR to really handle something like that, something about terminating people and all this, why? What? I don't care if you're husband and wife. I don't care. Do it professionally and do it right if you're gonna do it. So the CFO, who's the chief financial officer, That's, I mean, based on the last name, I'm assuming they're husband and wife. They could be sister and brother. I don't know. Told plaintiff of a rumor that plaintiff had a sexual relationship with a male resident in the hotel, predominantly for homeless. Is this real? They asked plaintiff if he was gay, which is illegal. You can't do that. That's y'all see what I mean by shy. This is raggedy as hell. First of all, if this be true, this is it's saying rumor, which I mean they would have to. It's my first time seeing this. Let me go back. I'm thinking myself through this. I'm not trying to stall or pause. I'm thinking myself through this situation where you're talking about something along the lines of what a third party said, landing in the background facts. Who typed this pleading up? This is the portion of the lawsuit filing or the complaint where you're strictly talking about facts that can be proven with evidence or documentation here. To say that two people told someone like third party of a rumor that's not substantiated thus far, and that is in the background facts. I just that's a little puzzling to me. I don't know if it should be here in this section. That's my whole thing. I don't think something that could be seen as, hearsay should be in background facts, because that could easily be challenged as hearsay. Two other people said this to my plaintiff when there's no firsthand account or evidence or anything. But okay, let's keep reading. That he had a S relationship with a male resident. Wow. Okay. They asked plaintiff if he was gay, which is not a question you ever ask anyone. Why are they talking to one of the vendors or one of their? It sounds like JPA was a client of PFH from what I'm reading it, how I'm understanding it. So why is a client going to the company that contracted with them about one of the vendor's employees again? Why? And asking something like this that is highly, you can't ask anyone this. You can't even ask an employee that's a woman walking around with a big belly. You can't even ask her if she's pregnant. That's something you don't just go to someone's, are you gay? Because I mean, you're opening the door to possible discrimination. That's not up to the employer to even ask something like that. If nothing else, regardless of that, why not go to PFH's superiors? Whoever he reported to under PFH, he was the supervisor, but unless this is his company, it can't be your company and you get promoted. Wouldn't you automatically be the head honcho? So there was somebody above him, at the very least, a manager or a director, somebody they could have went to and brought up just the issue of the allegation that he had a S relationship with a male resident, which would have been a homeless person. Going to him directly? What the heck kind of company is this? And then, I mean, like I said, this is true. No, this is a negative. It could be seen as fraternization, but then you're talking about being a contractor right now, or at least a client with a contractor. Oh man, is anyone else confused? I'm a little confused. I'm a little jarred. This one's got me stumped. They asked plaintiff if he was gay. Plaintiff denied the accusation of an inappropriate relationship, because that will be something that they would have to produce evidence to show. Just going to him asking, are you gay? Think about it from a legal perspective. That's, first of all, that's illegal and unlawful. That's not even an appropriate question anybody should be asking, but it introduces that discrimination based on sexual orientation. So instead of them asking directly about the accusation, they asking something like, are you gay? Now, I would have loved for this to be maybe in the foundation, the intro, and they actually stated the entire conversation, maybe, because it doesn't sound like that's the only thing they asked Jedidiah. It just seems like that's what kind of stands out to make this a discriminatory type of case based on, I think what he's going for is sexual orientation or sexual preference. So he denied the accusation of an inappropriate relationship. I mean, bottom line, they would need evidence of it. Either way, on or around June 22, 2020, JPA CEO Ronnie Jackson informed plaintiff that he discovered from a Huffington Post article that plaintiff was bisexual and decided to terminate plaintiff's employment. That can't be if that's the reason. I mean, what the heck? That can't be the reason. Even if they feel that way deep down, especially after having asked him give a pretextual justification of hiring 2 other gay male officers. Well, I hope that's not on the separation notice. Wait, really? First of all, wouldn't that be the job of PFH? JPA seems like, unless he was an employee directly under JPA, they really didn't have any standing to terminate him. That would be, or the company he actually is employed for. Wouldn't that be PFH? I'm a little confused. Maybe he was employed with JPA. I don't know. The way it's reading off to me, he was actually employed with PFH, and PFH just so happened to contract with JPA. But I could be wrong. I'm misinterpreting something. I'm missing these paragraphs. Because it says up here that PFH directed plaintiff's work at the hotel. Plaintiff attended daily meetings led by PFH supervisors. Plaintiff was responsible for adhering to PFH employment standards and PFH disciplined security officers and supervisors. And here it is, PFH exercised control over plaintiff's terms and conditions of employment, which means he was employed directly with PFH. This is something else. I'm sorry. This is a pause because I'm just trying to process this. Okay. So they read in the Huffington Post article that he was bisexual and decided to terminate his employment. That's not a reason that is just clear cut discrimination on sexual orientation. That's clear cut. Now, if they said, or there's a separation notice that reflects he was terminated by PFH based on an allegation that would still have needed a thorough vetting and investigation with evidence to prove that the actual, illicit act occurred, which I would never agree to that, with anyone doing anything when you're on the job, you're on the clock. I'm not saying he did it. I'm just saying that JPA should have allowed PFH to handle his termination, but an investigation where this evidence comes up. Let me just keep reading. maybe it's here. I'm on page what? Page 5? Okay. I told you I have to think my way through this in order to make sense of it, but let's keep going. So JPA CEO fired someone that worked with the client that they contracted with based on him being a bisexual, and that's not even the allegation of him, allegedly sleeping with somebody in a hotel. That's a homeless person. Now, Jackson also referenced plaintiff's racial justice advocacy as another reason for his termination. So because he's an advocate, why wasn't this meeting recorded? I mean, it's just that this is not something I would just have a verbal conversation with. You would have to put all that shit in writing to me for me to damn. Otherwise, I'm not taking you seriously, especially when I'm not employed with you. I'm not your direct employee. No. But what was the investigation done on the allegation? Okay. Count one. Sex discrimination. Plaintiff hereby incorporates each and every preceding paragraph as if fully set forth herein. So, like I've stated before, what they do is they just kind of reallege the preceding paragraphs when it comes down to the count. So they're realleging paragraphs 1 through 18. In 19 and in 20, plaintiff is bisexual and therefore a member of protected class under Title 7 because of his sexual orientation. See, there it is. Defendants discriminated against plaintiff by involuntarily terminating his employment based on the sexual orientation, not because of, the allegation that he fraternized with someone in the hotel itself. Was he on the clock? These are questions that are asked. Like I said, no matter how anyone feels about Jedidiah, these are the questions that are asked when you go to court. Was he on the clock? Was he actually working? If he wasn't, and he was in his private capacity off the clock, and somehow something was pursued with the residents, I wouldn't suggest that. I don't think you should, commingle, your job and your private life. But I mean, let's say something happened, he was off the clock and he chose to have something. Maybe he didn't know it was a homeless person. I don't know. It just seems weird. Okay, so defendants acted in bad faith, willfully and wantonly disregarded plaintiff's rights under Title 7 and acted in reckless disregard for plaintiff's rights under Title 7. Oh Lord. Defendants discriminated against him for involuntarily terminating employment. This is something else. As a result of defendants' unlawful actions, plaintiff has suffered loss, compensation, emotional distress, inconvenience, humiliation, and other indignities. Plaintiff is entitled to damages including back pay and lost benefits, front pay, compensatory damages, punitive damages, attorney's fees, and cost of litigation, and all other relief that they are entitled to under Title 7. Count 2 is race discrimination. So he's African American, member of the protected class under Title 7. Plaintiff is well-known advocate on behalf of the African American community. Okay, question: are the CEO and CFO, this Ronnie Jackson and Shea Jackson, are they black or white? I mean, I get it. People going to say you can be black and be racist towards your own kind. Yeah, but for the purposes of Title 7, were they also black? Because I think that would be a pretty hard allegation to kind of prove if all of them are African American. So based on the legal definition and the understanding and interpretation of Title 7, is typically done, like as far as race discrimination is typically based on another race discriminating against a separate and different race. But yeah, I haven't read up enough case law to see if there's been a situation where you can still be racially discriminated against by somebody of the same race as you. I would have to look at case law on that. Okay, so he was an advocate because of his racial justice advocacy. Defendants discriminated against plaintiff by involuntarily terminating his employment, but it doesn't really kind of support the allegation based on race discrimination or the count of race discrimination. It's more so he's an advocate, well known. It's a known fact he's African American. You can look at him and see that clearly, but the allegation or the claim itself is not pointing to race discrimination. I think the sexual orientation in and of itself would have been sufficient enough, barring he had evidence to, reiterate what they actually told him or what was said based on his allegations here. If there was some evidence of it, yeah, that would be enough. But I don't see anything in here that kind of, hits the nail with the hammer on the actual racial discrimination. And it's just based on me reading it. And y'all know I'm not an attorney, but this is just based on me reading it and knowing Title 7. It's more so It's more so focused on the advocacy and not him being a black person. So, all right. Defendants acted in bad faith. They acted reckless disregard for plaintiff's rights under Title VII. As a result of defendants' unlawful actions, plaintiff has suffered loss compensation, etc., etc. Plaintiff is entitled to damages, back pay. They basically, repeating the request of the relief that they're asking the court to grant. Count 3 is retaliation. Plaintiff engaged in statutorily protected activity by opposing conduct and actions made unlawful under Title VII. Plaintiff did this by advocating against the unfair and illegal treatment of residents and employees by defendants. Because of his protected activity, defendants retaliated against plaintiff by involuntarily terminating his employment. Defendants acted in bad faith. They just kind of realized that. So let's, I get the advocacy of them asking about the protectual justification to terminate 2 gay male officers. That's clear cut. They JPA, a whole nother company, coming to a client employee, that the client BFH employee who's a supervisor, not the CEO or VP or president or anything, a supervisor, asking for the justification of terminating 2 gay male officers. I mean, that will be a prime example, and there should be exhibits and evidence to support that. So, I mean, honestly, that if there was evidence and done right, that could have been something he did under the Whistleblower Act. Hey, they're sitting here violating, discrimination laws here. They're trying to get me to pretextualize and almost come up with some sort of justification why they wanted to fire 2 gay officers, and they're bringing me into it, of all people, and I'm just working with them as the company I'm employed with is working with JPAs as a contractor. It's yeah, okay, so that could have been something he reported under the Whistleblower Act if he, especially it would have protected them, him from just flat out losing his employment if they would have tried it. And you're already a whistleblower. You filed an ethics complaint under that protection, under that act. Then they definitely would have had to rehire him, because then that would have been clear retaliation. But I hope there's some exhibits on this, because this is wild. This is wild. Because of his protected activity, defendants retaliated against plaintiff. They acted in bad faith. There's once again lost compensation, distress, humiliation. Plaintiff is entitled to damages, back pay. So prayer for relief. Wherefore, plaintiff prays that this court assume jurisdiction of this action, and after trial, grant plaintiff a declaratory judgment holding. Yeah, I'm tired. Judgment holding that the actions of defendants described above violated and continue to violate the rights of plaintiff as secured by Title VII. Ooh, this is something else. This is something else, y'all. Okay. We got the declaratory judgment holding that the actions of defendants described above continue to violate the rights of plaintiff as secured by Title VII. Grant plaintiff a permanent injunction enjoining defendants, their agents, successors, employees, attorneys, and those acting in concert with the defendants and on defendants' behalf from continuing to violate Title VII. Grant plaintiff an order requiring defendants to make plaintiff whole by reinstating him to the position he would have occupied in the absence of the discrimination and retaliation as set out herein, or front pay, back pay, plus interest. Compensatory, punitive, nominal damages, loss of seniority and benefits. Why am I just? I can't talk today. Grant plaintiff is reasonable attorney's fees and costs. Grant plaintiff a jury trial on all issues triable by jury. Grant such other relief as the court and or jury deems just and proper. Submitted 2nd day of December 2020 by his attorney, Michael B. Schoenfeld. And you guys see the bar number there. So let me keep scrolling. Okay, so this is just the cover sheet. It goes with, federal, or it's lawsuits in general. You have a cover sheet here. And it just kind of gives background basic information. And let's see. Remember now, he went to EEO and they gave him a notice of right to sue. So I would nature of suit. So where's the notice of right to sue? This is a civil cover sheet. This come from EEO. I see the plaintiff, the defendants, the attorneys. I'm wondering if did they have an attorney? I think they did end up hiring an attorney. It just wasn't put on the cover sheet here. Basis of jurisdiction, federal question. Where is the notice of right to sue from the EEO? Is this? I'm not seeing anything where this is it. I would think that would be an exhibit as well. Just to show, he followed the steps based on the law of going to EEO first. So this is just kind of like, basic information. You guys saw jury demand on there. Okay. So I don't have all of the documents in case. I don't have all of the documents in this case docket, but for what I do have, I'm just going to kind of go through them real quick and skim over it. So this video is not 1,000 years long. So this is an order granting motion to extend joint preliminary report and discovery plan and initial disclosures deadline. Okay, so motion extend joint prelim report and discovery plan. So this is oftentimes what happens in the beginning of a case. You have what's called an exchange of discovery, and in civil procedure, it is required by law and court rule. In criminal matters, it's the prosecutor's job to ensure whatever discovery they have, whatever exhibits they have, they plan on using, that they have to give a copy to not only the courts, but also to the defendant. So being that Jedidiah was the petitioner, his burden was to prove, with the preponderance of the evidence, that the defendants are more likely, found guilty of the allegations. So that would be his burden as a petitioner. And that's kind of how it works all, across the board. So this is upon consideration of the parties' joint motion to extend the joint preliminary report, discovery plan, initial disclosures deadline. They pushed it back because, it happens. you end up having, an extension on when you have to provide discovery, depending on what you're trying to get. And they seem to have been in mutual agreement on that, both parties. Signed on April 23rd, 21. Ordered that the motion shall be hereby is granted for the extension of the deadline to complete all of these documents by May 17, 2021. So they had almost a good, I ain't gonna say a whole month, but at least a good 3 weeks. So ordered. Linda T. Walker, U.S. Magistrate Judge. Keep that in mind. There you go. She has beautiful handwriting. Good God, her signature is awesome. Yeah, keep that in mind. Let me make sure this is still going because I've been having, a couple of issues with StreamYard. Is acting funny and throwing tantrums. Oh my God. Y'all, this is something else. Oh my good God. All right. So y'all see that. Okay. So here's another document. Defendant Jackson Protection Agency, LLC's answer and defenses to first amended complaint. So that was an amended complaint that was filed. Hopefully it was to kind of define more of the racial discrimination, but I could be wrong. If anything, I would definitely have amended the complaint to kind of give, validity and have uh, an actual example to show racial discrimination and not necessarily the advocacy part. Because let's be honest, he could be white, Hispanic, or Latin American, or whatever, and still advocate. So it's not racial discrimination based on him being an advocate, because anybody can be an advocate. You got to prove where the discrimination of race lies, if that makes sense. So I definitely would have amended it for that. If I had to amend it for one good solid reason, it would be definitely for that reason. Let's see here. Then Defendant Jackson Protection Agency files this answer in defenses responding to numbered paragraphs in the plaintiff's first amended complaint. What I read in the beginning was the initial complaint. That was an amended one. And these are the responses from the defendant, and particularly Protection Agency LLC. There's two defendants listed. So each defendant is able to provide responses to either the complaint or a motion of some sort. They have the right by law to be able to be given the time and opportunity to respond, and have that on file with the court. Otherwise, if you don't respond, the court's going to see this as, well, obviously you're not fighting this motion or this complaint, so you didn't respond to it, and it makes it harder for you to defend your case. So I'm just going to skim over this. This is their response. Defendant admits the plaintiff claims alleged violations of Title VII of the Civil Rights Act of 1964 as amended. Defendant denies all remaining and or inconsistent allegations in paragraph 1, and specifically denies that plaintiff has stated a claim against defendant under any governing statute. One thing, let me go back to this initial complaint here. Like I said, I did not see the amended one, but if you guys look throughout, they have federal statutes cited. They have the allegations itself. What you don't see is case law. So, I would like to assume that the amended complaint had case law in it, because I don't see that here. There's no case law here. Okay. So, let's see. This is paragraph 1. Paragraph 2, jurisdiction and venue. Defendant admits the plaintiff invokes this court's jurisdiction over the subject matter of his claims. Defendant denies all remaining and or inconsistent allegations in paragraph 2. So if you guys go back here, well, just keep in mind when I am reading these numbers, they're responding to each. When you do a response, you have to respond to each paragraph. So if it's 78 paragraphs, you got to respond to every single last one of them. That's why they're saying you can say certain parts of the paragraph is true while other parts are false. Is no different than providing an objection. Basically, you're outlining why they're not true, or you're responding to it. And if you provide a response, at the very least, you have some sort of evidence to show why you're denying it. But that comes along with that discovery material, those exhibits and additional documentation. That's typically what's exchanged with the discovery. Okay. So in paragraph 2, they're also saying that they specifically deny the plaintiff has stated a claim. Again, defendant admits the plaintiff alleges acts or omissions occurring at a business which was operated within the jurisdiction of U.S. District Court for Northern District of Georgia, Atlanta Division, but denies all remaining and or inconsistent allegations in paragraph 3. Paragraph 4, defendant admits that plaintiff filed a charge of discrimination with the EEOC and filed this action within 90 days of the mailing date stamped on the EEO's notice of right to sue. Defendant denies all remaining and inconsistent allegations. So when it comes down to what I said earlier about background facts, it should be a fact that can be proven to be true, and if need be, with evidence and documentation. It's a fact that he's a black male, but I don't need evidence to show that. People could see that for themselves, right? The jury would be able to see, yes, he is a black male. But what they're admitting as far as acknowledging is the claim itself of the facts that would be what can be proven. It can prove that he did go to EEO. That's why I asked about a notice of right to sue, because that document, even if it's not attached to the complaint as an exhibit, I would expect it to be included in the discovery. So they're not going to deny anything that is factually correct. What they're going to deny is the allegation that is unsubstantiated, or the claim itself, especially when it's lacking case law. So that was something I know I brought up reading Stephanie Wiedeman's lawsuit. You need case law. You're alleging that federal laws here are violated, particularly pertaining to discrimination and retaliation in a protected class of individuals. You need to cite case law. That's, pretty much how that works. Parties. Defendant lacks knowledge or info sufficient to form a belief as to the truth of the allegation, paragraph 5. Paragraph 6, defendant admits that JPA is an LLC and provides security services to clients. JPA was at all relevant times registered with the Georgia Secretary of State. I don't want to read it all because it's just kind of reiterating the paragraphs itself. Let's see. Defendant lacks knowledge of info on paragraph 7. Factual allegations. Defendant admits the allegations in paragraph 8. See, that's where the parties here, this is where that allegation about the CEO and the CFO going to Jedidiah, basically saying, or alleging that he had relations with a homeless resident or whatnot in the hotel, or in general, just had something going on with him. But I don't know, it's hard to put it. That the way it read to me, by citing what a third party has said, even if they are the CEO and CFO and they are the defendants here, typically you rarely see, this person told my client this, and this, because that could be objected to as hearsay. You don't want that. You just want to be able to say, my client alleges, that there was a question or allegation of him having relations with a resident in the hotel. Like, keep it that simple. That's kind of the point. Don't add more to that. That could easily be seen as someone told something to someone else, and that's kind of like third party information. And they would have been in a hearing to be able to negate that. If they truly did or did not say it, they would have had to prove that they did or didn't. He has to prove they did. They would have to say, okay, where's the evidence? But why wasn't that phone call recorded? I would have recorded that damn call or meeting or whatever they had with him when they asked him about that allegation, especially when they terminate him. No, you're not going to talk to me over a phone. You're going to have to send me an email. And what's the separation notice? Okay. So, So, of course, the facts that they're, agreeing to are facts that can be proven. You can go on the Secretary of State's website, see the business license. That's just indisputable, right? Paragraph 7, they lack the info sufficiently to form a belief of any sort. Factual allegations. They admit the allegations in paragraph 8. Defendant admits that on April 23rd, 20, it engaged plaintiff as an independent contractor security officer, and that approximately 2 to 3 weeks later, it promoted plaintiff to supervisory security officer, and he remained in that position until he was terminated on June 22nd, 2020. So that wasn't even a full 2 months. April Yeah, you're talking about 2 months exactly between what him being hired and being promoted. Defendant admits the allegations in paragraph 10. Defendant denies allegations in 11. Deny. So between paragraphs 11 on down to paragraph 18, they denied it. Pretty much it. Count one, sex discrimination. Defendant lacks knowledge or info sufficient to form a belief. They deny paragraphs 21 through 24. On count two, race discrimination. Defendant incorporates its answers to all preceding allegations. Um, Defendant lacks knowledge or info sufficient to form a belief. Defendant lacks knowledge or sufficient to form a belief for paragraph 27. And then paragraphs 29 through 31, they deny. Count three, retaliation. Defendant denies allegations in paragraphs 33 through 37. Prayer for relief. Defendant denies the assertions and allegations of the unnumbered paragraph under the heading prayer for relief, subsections 1 through 6 inclusive, appearing at page 11 of the complaint. So they're basically telling the court, this prayer for relief portion of the complaint, they deny any allegations or assertions in that paragraph. Let's see. General denial. To the extent not specifically addressed above, defendant denies each and every other allegation not expressly admitted herein. Defenses. First defense. Plaintiff claims to fail to state a claim. Second defense. Some or all of plaintiff's claims are barred by the equitable doctrines of estoppel, laches waiver, and or unclean hands. Third defense. Some or all the plaintiff's claims are barred by the applicable statute of limitations. The second defense, so they're basically saying in the second defense, they are somehow barred by the equitable doctrines of estoppel. It's almost like we're denying it. We're denying that. Now defense is, if anything were to happen, we don't have, we should not be directly blamed here. But I don't understand it, how JPA could fire him when he was not their employee. They clearly stated that he was an independent contractor. So what was the premise to them firing him when he was not their direct employee? Let's see. Third defense, some or all of plaintiff's claims are barred by the applicable statute of limitations. Fourth defense, all claims brought pursuant to Title VII, which were not included in charges filed with the EEOC or investigated by the EEOC, are barred because of the failure to satisfy statutory prerequisites, failure to exhaust administrative remedies, and or because of a lack of subject matter jurisdiction. So, anything that is not included in the charges filed with the EEO, they're saying should be omitted, because part of the law is that, on any claim of discrimination, you got to file something with EEOC, and you make sure that every single claim you have is listed in that particular complaint with EEOC, because that's the first step before you actually file a lawsuit on discrimination against an employer in the state of Georgia. So, and then of course there's a timely filing limit. I have to look that up. I thought it was 90 days. Maybe it's 180 days, something to that extent. So you only got so much time to file a complaint with EEOC to begin with. Let's see here. And then of course they speak on this failure to exhaust administrative remedies. Basically, if there was some lingo in the contract that says that, you must try to arbitrate. And then of course, depending on if it's just heinous and egregious and you have a solid case, then file your complaint with EEOC, and then they say go ahead and proceed with the right to sue, then you sue. But most times these companies utilize this arbitration thing as a method to try to, prevent you from actually just flat out filing a lawsuit against them. But, clearly there's plenty of case law that can be utilized to show that if people want to file a lawsuit, even if the EEO does not grant, a notice of the right to sue, you went through the proper channels. And if you have a credible, case here with evidence, people are still going to file a lawsuit. So all claims are brought pursuant to Title VII with respect to acts, events, or omissions occurring prior to 180 days before the filing of charges. So the timely filing limit is 180 days. You got 180 days, between the incident occurring or termination or whatever, the claim is under Title VII. You have 180 days to file the complaint with EEOC. Anything beyond 180 days, they're saying basically, it should not be considered in this lawsuit because it wasn't included in the charges or the complaint filed to EEOC. So, lesson learned for all of you out there: make sure you state everything when you go to EEOC. If you got to do that, put every single thing down. You want it to be covered. If you get a notice of the right to sue, you want every single claim allegation to be covered and added to the complaint first with EEO before it goes to a matter where you have the right to sue and it goes to a court. Because the defendants, their attorneys, they're going to say he didn't put that on the complaint with the EEO. So it needs to be omitted from this lawsuit because it was supposed to go through them first. Every single allegation was supposed to go through the EEOC. So just a heads up out there, anyone that's going through something like that with your employer, make sure you tell it all. Don't leave that out. All right. 7th defense: plaintiff acted unreasonably by failing to take advantage of defendant's preventative and corrective measures, by failing to notify defendant or any of his agents of allegedly unlawful conduct. My question is, wouldn't he have done that with PFH? He's their employee. It will be on PFH to say, hey, one of our employees came to us about this, and we're coming to you all about it. It should not have been a matter where they're expecting him. It sounds like they're expecting him to do things that a normal permanent employee would do with their own company. More of a reason why I looked up the website, because, mighty funny how I don't see a corporate headquarters or the legal department or anything like that either. Because if they had a legal department or a legal team, I hope that the attorneys would have told the CEO and CFO of JPA, you don't have the authority to terminate someone that is an independent contractor of a vendor you're contracted with. It's their responsibility to terminate him. That makes no sense. That should have came through PFH, as well as a notice that he's filing a lawsuit. He would have had to, have notified them by e-serving or whatnot. But that is the heads up. They're not gonna. They expecting him to call them and say, "Hey, I'm about to sue you all. Kiss my ass." What is that? Oh, you go to your own employer, and your employer says, "Listen, one of our employees, have just given us some documents to show they plan on suing you all." But I've never heard of a situation where the independent contractor is obligated to speak with the client directly to say, "I'm about to sue y'all." You find out when you get served the summons. I don't understand. When you get served this complaint, that's when you find out. This is why you also have what's, considered discovery, because now you get to present this information, to the defense that you plan on introducing to the court as evidence, to justify your allegations here. But I've never heard of a scenario. If I'm a contractor, I need to call, the client as opposed to my actual company that hired me and say, "I'm suing y'all." PFH would have ensured that an arbitration was attempted, but that should have been facilitated through his employer. Good grief. Plaintiff is not entitled in the 8th defense. Plaintiff is not entitled to some or all of the relief requested in the complaint, because even if any unlawful discrimination or retaliation occurred, which defendant denies, defendant cannot be held vicariously liable for alleged discrimination, retaliation, or other misconduct, which is contrary to defendant's policies, procedures, and good faith efforts to comply with applicable laws. So they're saying you didn't even tell us and give us a chance to figure out what was going on, to learn of the allegations, yada, yada, yada. But like I said, that would have been PFH's job to do that and come together to try to do some sort of, arbitration. But why did JPA think they had the right to terminate him? I mean, it make it, good grief. Okay, so ninth defense, some of the forms of relief sought in the complaint are barred because the actions and omissions complained of were taken in good faith and based on reasonable grounds for believing such actions and or omission were not in violation of Title VII. 10th defense, you guys can see that here. This is like 13 pages. Employment actions taken do not constitute violations of Title VII. All actions were based on reasonable factors other than any alleged protected activity and were taken for legitimate, non-discriminatory, non-retaliatory reasons. Alternatively, even if any alleged protected activity were a factor or factors in the employment decision taken, such protected activities were not motivating or determinative factors in any action or inactions taken by defendant, as defendant would have taken such action anyway for legitimate, non-discriminatory, and non-retaliatory reasons. So they're saying, listen, we got a complaint. It was named as rumor in the actual lawsuit, which I would not have named it that way. But, JPA is saying, we got a complaint. We heard of him, having some relationship with a resident in the hotel that he is working at as an independent contractor. And we went and investigated it. Here's the evidence, the exhibits, in good faith, despite his advocacy, his race, or sexual orientation. And then that would bring about the question, would this be any different if it were a female saying the same thing against him? So they're saying we received a complaint or allegation or rumor or whatever. We received some disturbing information and we took it upon ourselves to investigate it, even though PFH should have been more so involved. But okay. I'm still not seeing any evidence of their actual investigation on this. Even if plaintiff had exercised his federally protected right to oppose allegedly unlawful employment practices, which he did not, defendant had no knowledge of plaintiff's alleged exercise of these rights. Laws are laws. You're saying, okay, even if he exercised his federally protected right to oppose allegedly unlawful employment practices, if he said, this is unlawful, I'm not in agreement with what you all are doing with your employment practices, he had no knowledge. They had no knowledge. Defendant had no knowledge of plaintiff's alleged exercise of these rights. Wait, what? I mean, if he went to them and say, you know what, you guys just asked me to give a pretextual justification to terminate two, officers that are gay, how is that not telling them that he's exercising his right to say no and that he would never want to do that because it's unethical? Wouldn't that be an exercise of his right to say, I don't agree with your employment practices? I don't agree with you all coming to me asking me to justify terminating two officers that seem like they were also independent contractors as well. First, why aren't you going through PFH again, JPA? Why didn't you all go to the actual company you were contracted with? Jesus Christ. This is why I keep getting confused as to whether he was directly employed with JFH or JPA. because JPA is conducting themselves like they were his direct employer. 12th defense, neither defendant's actions nor the actions of anyone within defendant's control were the proximate cause of plaintiff's alleged injuries. 13th defense, he suffered no damage as a result of defendant's conduct. Therefore, he's not entitled. 14th defense, defendant is not liable for punitive damages because neither defendant nor any of his employees or agents committed any act with malice or reckless indifference. 15th defense, punitive damages are unavailable because defendant has not willfully violated any law or regulation, has acted in good faith at all times to comply with the law. 16th defense, plaintiff's claims for punitive damages are barred in whole or in part because excessive punitive damages are unconstitutional. Huh? What was the amount he was asking for? I'm wondering if it came up in the amended complaint of the amount he was asking for. They're saying it's excessive. Okay. 17th defense, plaintiff's claims for compensatory and punitive damages should be stricken to the extent that they are speculative in nature and or have not been pled with sufficient particularity. 18th defense, plaintiff failed to exercise reasonable diligence to mitigate or minimize any alleged damages. Alternatively, if plaintiff did mitigate his alleged damages, defendant is entitled to an offset. Okay. They're basically saying, if he did mitigate the, alleged damages, then we want an offset between what he's mitigated, what's happened with him on his end versus what the court would order us as, to pay out as a judgment. If they were, if he is, if the case was in his favor, the ruling in his favor, and he was granted the judgment, naturally they would ask for some sort of offset to try to lessen the amount of money they would have to pay. 19th defense, claims from the plaintiff are barred in whole or in part because any unlawful discrimination or retaliation by employees or agents of defendant, which defendant expressly denies, was beyond the scope of their employment and was neither authorized, ratified, nor condoned by defendant. 20th defense, plaintiff is not entitled to some or all of the relief. 21st defense, to the extent plaintiff claims that he was retaliated against by defendant, any alleged adverse employment action taken against plaintiff by defendant resulted from plaintiff's own unprotected conduct. So they're saying, we retaliated against you, is your fault. I'm still waiting to see some evidence on this allegation of him having relations with a resident. Where is that at? 22nd defense, because they would need that to justify them directly terminating him and not PFH. Defendant reserves the right to plead and assert additional defenses as discovery or further assertions by plaintiff should hereafter dictate. All right, defendant's demand for relief. Having fully answered and responded to the allegations, the defendant respectfully requests that plaintiff's claims be dismissed with prejudice in their entirety, and each and every prayer for relief contained in the complaint be denied. Judgment be entered in favor of defendant. All costs, including reasonable attorney's fees, be awarded to defendant against plaintiff pursuant to applicable law. Defendant have such other relief as the court may deem just and proper. Respectfully submitted, 26th day of 21. And the attorney for Jackson Protection Agency is Gregory Fidlin. And then there's a certificate of service basically saying, we served this document. I know in Georgia you can e-serve depending on the case itself. You can just load it up in the system here, which is what they did here, electronically filed the answer and defenses. And they used the CEM-ECF system, which is the electric system. So he was he e-served, and they e-filed and e-served the document. So this certificate of service is saying we e-served it. What they should have did was added the email addresses that this was e-served to, but Then there was this document consent motion to extend response to motion to dismiss. So they filed a motion to um, extend the response on the motion to dismiss. Like I said, the defendant has the right, both parties have the right to provide responses to the other party's pleading. So if the defendant filed the motion to dismiss, then the plaintiff would have the right to file a response to that motion to dismiss. But here it says a consent motion to extend the response to motion to dismiss. So come now, Jedidiah Brown, being the plaintiff, respectfully requests a 21-day extension of his response to defendant partners for Home Inc.'s motion to dismiss amended complaint. In support of the request, plaintiff shows the court as follows. Plaintiff filed his First Amendment complaint in this action on March 12, 2021. On March 26, 21, defendant partners for Home Inc. filed a motion to dismiss the First Amendment complaint. Plaintiff's response to the motion to dismiss is due on April 12, 21. All parties in this case have reached agreement on the material terms of a settlement of this matter, which will include dismissal of this action with prejudice. Parties are currently working to finalize the settlement. Accordingly, plaintiff requests a 21-day extension to May 3rd, 21 to file a response to the motion to dismiss in the event that the parties are unable to finalize the terms of their settlement agreement prior to the date. So they both agreed to settle here. They reached an agreement to settle on the material terms of the settlement of this matter. And that included, of course, a dismissal of this action with prejudice, which means he can't go back and try to sue again on this. And while they're working on, finalizing the settlement itself, they went ahead and requested an extension, because what if the settlement doesn't go through and they can't, meet eye to eye on that resolution? Because neither party has to accept some sort of agreement as a part of a settlement. So if either party rejects the, settlement and they cannot come to an agreement on their own accord, then they would need an extension to respond to that motion to dismiss, which is kind of like covering all the bases here. If they did agree, then the motion to the responses on this and the extension would be a moot point. This motion is not sought for the purpose of delay or any other inappropriate reason. Defendant partners for Home Inc. has consented to the extension sought in this action. A proposed order is attached. You have the certificate of service, e-file, e-served. This is the proposed order. So when it's not signed by the judge and filed with the clerk of court, the attorneys or either party, even if he represented himself as pro se, you have to submit, a proposed order for the judge, because they don't like to have to type this stuff up. They don't like reading long, documents and motions and complaints. You talking about a criminal matter, that's one thing, but they don't like to read all that stuff. They want you to truncate it and keep it as simple and straightforward and to the point as possible. So, but anytime you have a motion filed, each party has to submit, either like a pretrial order or a proposed order of some sort, and if they're granted that motion, then the judge signs that party's proposed order based on that motion. So this is their proposed order, and it was submitted over to, as you all can see, if granted, the Honorable Linda T. Walker, U.S. Magistrate Judge, Northern District of Georgia, would have been the judge to sign the order. All right, this is the plaintiff's response in opposition to defendant partners' motion to dismiss of the first amended complaint. And I'm just going to kind of scroll through. Now, this is, this is better just written as far as a response. You see case law here, which is what, you kind of expect to see in the complaint or even the amended complaint. But this is case law. So they give the introduction to the response from Jedidiah Brown. We're ruling on a motion to dismiss. Courts accept the factual allegations in the complaint as true and construe them in the light most favorable to the plaintiff. And then they have case law cited here. To survive a motion to dismiss, a complaint must set forth a claim that is plausible on its face. And then you have Case law cited. The plausibility standard requires that a plaintiff allege sufficient facts to raise a reasonable expectation that discovery will reveal evidence that support the plaintiff's claim. Like I said earlier, when you file in these types of lawsuits and you're talking about a federal lawsuit, the federal courts are not for play. Federal judges are not for play. All right. So you need to make sure you have evidence to support your claim. Same thing I said about, that JPA presenting some evidence to substantiate their allegation of Jedidiah having a relationship with a resident. If they did an investigation, and that would have to be with JPA and PFH, his direct employer, then they would have to show proof of this before taking action. So that goes, both sides have to present evidence to substantiate their claims. Bottom line. Or the court is going to be like, okay, why are we here? Why are we here? You have no evidence. What are you doing? Even in a civil matter, you need evidence. You need something. Let's see. And then they have case law cited, plaintiff's amended complaint, alleged sufficient facts plausibly show Partners for Home was plaintiff's joint employer from April to June 2020. PFH terminated plaintiff for an unlawful reason. Okay, this is what I was saying. Well, why did JPA? They had it in this complaint. JPA was the one that terminated his employment. Am I missing something here? Hold on. This is the original one. So like I said, I didn't read the amended one. I mean, but a fact is a fact. If it were JPA and not PFH, then that would have been consistent even in the amended complaint, because it would have just been a fundamental fact that it was JPA that terminated him. Where's the separation notice? And then this allegation is wild. If they did that, that is crazy. You went to an independent contract on that. I'm just trying to look, it says here in the original complaint, JPA CEO Ronnie Jackson informed plaintiff that he discovered about, a Huffington Post. Plaintiff was bisexual and decided to terminate plaintiff's employment. It does not even specify that JFH decided to terminate plaintiff's employment. And when you're reading court documents like this, there should not be any room for gray area. Even from the defendant's responses, there should never be any room for gray area here. This is too. I mean, anyone reading this would assume that JPA was the one that terminated his employment, because you don't even see PFH listed in this paragraph. So that's why I kept getting confused about which company he was actually directly employed with here. Okay, so PFH terminated his employment for an unlawful reason. The amended complaint alleges facts necessary for the court to draw reasonable inference that PFH is liable for the conduct alleged. And then, of course, they have, some case law. Accordingly, PFH's motion to dismiss should be denied in its entirety. Oh, man. They're saying that the amended complaint alleges sufficient facts to plausibly show that PFH was plaintiff's joint employer. The way that comes off is like he worked for both companies, when in actuality he worked for PFH and was part of that company, and they contracted with JPA. I don't think that's the same as being, employed as a joint employer. Your company just has a contract with the other company. So that's I've never heard it put that way when it comes to being an independent contractor. So they hired him to JPA, a security services company, hired plaintiff to work pursuant to his contract with PFH. Yeah. So, I mean, that's not a joint employment. It's just PFH you know, contracted with JPA. He works for PFH. That's it. JPA should not have had anything to do with anything regarding one of the employees, employment status or anything. This is why I keep kind of just staring a little bit, because I'm just trying to make sure I'm understanding this correctly. I'm not an attorney, y'all. I'm just reading the document. All right. While working at the hotels, PFH exercised control over plaintiffs' terms and conditions of employment, setting plaintiffs' wage rate through its contract with JPA, directing, assigning, supervising plaintiffs' work on a daily basis through its emergency response manager, Asher Morris, and other PFH agents, directing plaintiff to discipline and fire JPA security guards, requiring plaintiff as a condition of employment to attend daily meetings, requiring plaintiff to adhere to PFH employment standards. The above cited allegations plausible show PFH was plaintiff's joint employer under 11th Circuit precedent if one employer, while contracting in good faith with an otherwise independent company, has retained for itself sufficient control of the terms and conditions of employment of the employees who are employed by the other employer, that defendant may be liable as a joint employer. So they're trying to bring the liability under this, what they cited here, the 11th Circuit precedent, simply because PFH and JPA were contracted to work together. But if JPA CEO and CFO even had anything, just a shred of iota to do anything with him being terminated on a rumor allegation that they did not investigate, that PFH should have investigated, then yeah, I mean, I just don't understand why would they doing too much. They doing too much. JPA doing too much. All of this should have been done directly with PFH. JPA is just doing too much. They invoke themselves. The CEO, the CFO dealing with finance definitely invoked herself into this matter, and she should not have been a part of it. You leave that to your legal team and HR. My Lord. So they're citing case law here. Thus, to be considered a joint employer, PFH must have retained for itself sufficient control of the terms and conditions of employment over plaintiff while he worked pursuant to JPA Security Services contract. All right. 11th Circuit Court of Appeals explained that it accorded a liberal construction to the term employer under Title VII, and then they have case law cited here. I'm just going to kind of scroll down. This is 17 pages. Y'all can take time to read this, but this is the response. And this is kind of what I would expect the actual complaint to read as. This is pretty lengthy, 17 pages long. Especially when you're citing case law, you're providing, what the law defines certain terms to be. On-site security. JPA will provide on-site security services. This is a part of their scope of work and budget that you will see in an RFP or a contract agreement with a vendor. They have the employees that they have, how much they're going to get paid, the hours they're going to be working, so that when PFH sends invoices over to JPA, they're invoicing them for the labor for the staff based on what the contract states and their agreement to that contract. So you will see this information here. You should actually see the name of the employees in the RFP, and then of course translate over to the contract if seeing that PFH was awarded the contract. Because what you don't want is PFH billing labor hours to JPA, and the timesheet, the labor, whatever, is not even correct. The pay rate is incorrect, or the hours worked is incorrect. You have to send a certified hours or payroll timesheet as the vendor. You have to send that with the invoice over to the vendor you're billing. So PFH would have had to send all of this to JPA in order for JPA to remit payment over through based on the contract. So they had 6 officers at 12 hours per day, 30 days per month, 3 officers per 12-hour shift. They got the times worked here. $16 an hour was the pay rate, 15% retainer, totally monthly expenses that they should expect to see on the invoices. And I'm assuming this invoicing is like a net 30 where you send an invoice every month. Because I mean, what employer is going to wait 3 months to pay their staff, right? I don't know any job that really operates like that. So naturally, you would expect to see this amount when it comes to the labor on a monthly invoice submitted. And this could be like the total for the contract itself that they're expecting to pay out to PFH, they being JPA. Let's see here. We're going to keep scrolling down. And if you're listen, I got in a couple comments about this, like you scrolling too fast and all of that. Be honest, I'm not gonna read this entire thing because this live stream, this video would never end if I had to do this. So just for the sake of brevity, I scroll through it so you guys can read it. Court documents are public documents unless there's a seal or information that is to be redacted. A situation, if it's sealed, you got to submit a request to get, the case unsealed just to get case information about it. If it's sealed, it's sealed. Sealed to the public, you can't see it. So these court documents, could be FOIA from the court. Let's see. So I encourage you all, if you want to be able to just kind of take your time and read it, you can definitely check out this video and hit the like button. And you can kind of slow it down, change the speed of it, slow it down and pause it to read if you want. I try my best to go as slow as I can, but I don't want the videos to be overly lengthy either. But yeah, reading is fundamental. I told you all, these court documents be something else. Something else. Let me scroll down to the bottom. Let's see here. Yeah, I think I'm gonna let this go ahead and live stream because this is a lot of information. And then, go ahead and put this up to members only. Let it just kind of run for a couple days and then post it up to members only and lock it down. I think that's what I'm gonna do. All right, they got the conclusion here. For the reasons above, plaintiff respectfully submits the PFH's motion to dismiss should be denied in its entirety. You even have the footnotes here. So to kind of help give you some understanding of these things that's being cited as you read through the actual pleading itself with the responses. And you have your certification of compliance. And you have your certification of service. This is e-filed and e-served. Boom, shakalaka. All right. So here's an order here. This matter is before the court of the magistrate judge's report and recommendation, R&R 13. No objections have been filed in response to the magistrate's report and recommendation. Therefore, in accordance, and judges will give a report and recommendation to kind of give guidance on, based on the application of law and case law. They will write an opinion or like an op-ed. You see that oftentimes with Supreme Court justices when there's a hearing and there's a ruling, especially if you have, 4 or 5 judges vote one way and the other ones, the remaining 9 will vote a certain way. Those dissenting judges will oftentimes pen an op-ed to justify why they either, voted it for or against something. And that's not uncommon. It's common to see that. It's not something that's kind of just a standalone thing. It oftentimes happens. So magistrate report and recommendation was submitted to both parties here. In my understanding, they were trying to reach a settlement agreement in that response to the motion to dismiss. Therefore, in accordance with 28 USC Statute 636 sub B1 and Rule 72 of the Federal Rules of Civil Procedure, which is court rule. The court reviewed the magistrate's recommendation for clear error and finds none. Accordingly, the court adopts the magistrate's judge's report and recommendation as the opinion of the court. So, like I said, it's an op-ed basically. I'm not gonna read that op-ed because I'm sure it's lengthy. A lot of legalese and case law and stuff being cited in it, and you know, like I said, you guys can make sure you get some of the documents that, like the amended complaint, the report and recommendation. Those are things you can still get, from the court with a FOIA. Defendant Partners for Home Inc.'s motion to dismiss is denied as moot. There you go. Denied as moot. So, plaintiff amended his complaint as a matter course, rendering the motion moot. And then you have case law cited, and it is so ordered. And there is Lee Martin May, U.S. District Judge. So the U.S. District Judge is a step up above the magistrate judge. And this is federal court. These are federal judges now. They're not elected. They're appointed. Yeah. All right. This is the last piece of documents I want to show. Joint stipulation of dismissal with prejudice. So once again, they, came to some sort of settlement agreement, which included that there has to be a dismissal with prejudice. So they stipulated to such. This wasn't a matter of win or lose. It was a settlement agreement reached. Part of that included this matter being dismissed with prejudice, meaning you can't go back to court on this because you reached a settlement, right? So it's the same thing with a plea deal. Take a plea deal. Oftentimes, the law will not allow you, and I'm talking about state law, will not allow you to actually file an appeal. So if you take a plea deal, you cannot go back and appeal it. Don't believe me? Look it up. So it's kind of the same concept. We reached a settlement. Now you have to dismiss this with prejudice. Because if you agree to a settlement, that means you agree to, the allegations, the facts of the case to be resolved, and the actual agreement, the settlement itself, is pretty much a resolution, which would warrant the case to be closed and dismissed. So come down plaintiff Jedidiah Brown, as well as defendants Jackson Protection Agency LLC and Partners for Home Inc., by and through the undersigned counsel of record, hereby stipulate pursuant to Federal Rule of Civil Procedure 41 sub A ZL A2 to the dismissal with prejudice of the above captioned case and any and all asserted claims. Each party will bear his or its own costs and attorney's fees associated with the above captioned case. If they did reach an agreement, I'm sure if it was agreement that was favorable to the plaintiff, that attorney's fees were included in that. I will find it hard for that not to be the case, because that means the attorneys did all this work for nothing. So they're going to have to get paid somehow. And this was done on 13th day of May 2021. So the lawsuit was filed December 22nd of 2020. And they came to an agreement stipulated to a motion to dismiss with prejudice by May 13th of 2021. So you're talking about 5-6 months later. That's pretty quick considering. And we were in COVID in 2020 and 2021. Yeah. So I had a COVID. So see the certificate of service. That's pretty much it. That is the entire case that I pulled the documents for in a nutshell. This is something else. This was something else. I wanted to go through this because the twist. The twist. What's the twist, Lady Luck? What's the twist? Told y'all to keep in mind. The magistrate judge, Linda T. Walker. All right, let's get to the twist. Y'all, y'all, see that? I use this video as a part of my reporting on a corrupt judge, Shamila Williams of Fulton County Superior Court, to show a contrast between a city girl judge that's under investigation with 15 charges by the JQC versus a judge that acts with, you know, integrity and character and ethics. And y'all see here, I even labeled a video that Super City Girl Judge in Fulton County under fire versus Honorable Magistrate Federal Judge in Georgia. I'm going to play this so y'all can see this here. Hope y'all don't mind. I want to play this. Thank you all for bearing with me and being able to sit through this. I know it's a lot of reading. Please, for the love of God, just speed up the video. Because I wanted to present as much information on that case docket as possible. And here's a twist right here. So I dote on my godmother. I do. I am very proud of her, and I'm immensely blessed to have her in my life. But one of the things that I truly admire is his work ethics and integrity. Even at the threat of it being questioned, her ethics comes first, and it's just something that needs to be reinstated. Like these younger judges coming up, Christina Petersons and Shamila Williams, need to remember. Yeah, look at this. I'm just gonna fast forward.
That's another thing too. A lot of times the federal clerkship, and I forgot that part of it for those law students. Federal clerkships are very important. Oh. They're very hard to get. And for me, again, the dean of the law school put me on the list with other people, and I got a call to the dean.
I just want to point out, she said in this interview that she applied for med school and law school at the same time. What is your IQ, woman? Y'all, the Honorable Judge Linda T. Walker is my godmother. Sweet Jesus, this could not. This could not be more ironic. Yo, the judge that had some dealing in this case I just went over. This is an old case from 2020. Because, you know, she has a lot of integrity and ethics. She does not talk to me about her cases. I would have to research her case docket, which is, you know, something anybody can look up. You can look up any judge's case docket on, you know, whatever court system website they're employed with. I would have to look at the cases assigned to her. And I guarantee you in 2020, I had no idea who Jedidiah Brown was. Hell, I didn't know who he was until I started really heavily reporting on Dalton. I didn't even think he was always on YouTube. Was he always on YouTube? When did Jedidiah get on YouTube? Yeah, who would have thought? Who would have thought? And as you can see, she was the magistrate judge in the matter. And you saw her signature in some of those documents. This is my godmother that was so to get this. The irony of this is mind blowing. Who knew? I'm wondering if Jedidiah knew when I did this video. I did a post too. I did a post on her for Black History Month. Let me go to my channel and go to post. Oh Lord. Y'all love Adam Lambert. Let me scroll down. Oh my God. How long? I featured her as my so-called Black, you know, my sort of like Black History tribute. Ooh, man, I got a lot of posts. Hold on, hold on. I'm gonna scroll down. I'm gonna scroll down. Yeah, I love supporting other content creators. Look at this clown. I even post up the items, the support. Look at it. Xfinity Internet. So y'all can see contributions are at work. I feel it's only right to do, especially if you guys are supporting the channel. I feel like it's only right for you to actually see that your contributions are at work. I'm still going, y'all. Look at this. This is my black. This is what is this? A month ago. This is my Black History. 365, celebrating hidden treasures, making great strides in history. And I gave a whole spiel here. It's my honor to introduce the Honorable Judge Linda T. Walker, being the first and youngest African American woman to be sworn in as a federal magistrate judge for the Northern District Court of Georgia in 2000. And I gave some background on her. And she also did this little interview podcast that I've given a link to that video if you guys want to check out her interview. Y'all, look at this. Who knew? Y'all, this twist is something else. The irony of it. This was something else. Oh, we love her dearly. I love her dearly. Yeah, this is the irony. The irony. You never know how you end up being intertwined with individuals. You just never know. You never know. You never know. Who child? More of a reason why I still want this to be, directly to the members. But I think I'm gonna go ahead and live stream this as a premiere. I'm gonna do it as a premiere. And then put it in the members only. This is something else. But I am proud of her. I'm proud of her. I am I gotta say, my interest in the law does not go beyond don't go beyond me doing what I'm doing now. Reporting and researching and looking up case documents and being able to share that. I this was the reason why I did this, because I saw the docket and the court, the case information. I said, oh, okay. Y'all, of all the judges in the Northern District Court of Georgia, and it's like 7, 8 of them. My godmother was assigned the case. You can't make this up. You can't make this up. Oh, good Lord. Oh, man. But I mean, if you read her report and recommendation, you'll see how well knowledgeable and well versed in the law she truly is. She's really smart. Like I said, she applied for med school and law school at the same time. It was just a matter of who's taking me first. The law school did. So that's then she went to law school, became an attorney. She worked in, I think, the DA's office, and then did another government job. And then, of course, was, appointed to be a U.S. magistrate judge. And I could not be more happy for her. I'm just absolutely elated. Preferably she resigns soon, because judges out here just doing weird stuff. And I'm more so concerned about her safety than anything else. People acting up. You got these crazy folks out here running around. They don't even have respect for judges nowadays. And of course, if we have an example sitting in the executive branch that does not have any regard for a court order or laws or the courts or judge, for that matter, when he's calling for judges to be arrested because reasons, that's more of a reason for me to be on edge. I am on edge every time she goes to work. I've been on edge for over 20 years. Oh my God. So let me tell you all something. She has the innate ability to capture the presence of a room. And looks just like me. And I love her. All right. That's all I got, y'all. This is the oh man. The juiciness of this with this twist. Like, who knew this? Who knew? So thank you all for tuning in. Make sure you hit the like button. Thank you all for rocking with me. I appreciate all of you. I'm going to be going live tonight. Tomorrow is Mother's Day. Happy Mother's Day to all the mothers that are watching this. Please share this video. It's only going to be available for like a day or so. And then it's going to the members only. You look at that. And I'm going to restrict it and make sure that, if it's members only, the members get to enjoy this. They get to enjoy this. I might put it up there as soon as this gets through premiering because I don't feel like downloading this entire 2-hour video. I don't want to download the whole 2-hour video like that. I really just premiere it and then move it to the members only. So that's what I'm gonna do. I'm gonna premiere it tonight. I'm also gonna go live. Thank you all for rocking with me and tuning in. I want all the mothers to take care out there. I'm gonna enjoy my children this evening. That's why I'm trying to get a head start on some of these videos and stuff. And be sure to stay on the lookout for that judge I am reporting and researching on, Judge Shamila Williams. She has court hearings coming up. We will be going over the court hearings, and I hope it's televised or at least recorded. They need to live stream it. If it were more attention being brought to that judge, they probably would, because you get a court reporter. That case is sitting with the Georgia Supreme Court. So there's going to be a court reporter there. But the other judge that was removed from the bench last year, Christina Peterson, or was the year before last? The year before last. Her hearing were recorded in video, and we were able to watch that. And I did watch a little bit of it, but the allegations and what she was being investigated for by the JQC speaks for itself. She wrongfully, put a woman in jail, took her liberty and freedom because of a marriage license. And this was Christina Peterson. She got booted off the bench, rightfully so. And it should be the same for Judge Shamila Williams. You want to act like a city girl judge, may be biased and fail to remain neutral and impartial, doing the things that you've been accused of doing, unlawfully detaining someone because you don't like girls with daddy issues. Who cares about that? That's a dumb thing to even say or think. The public humiliation of that young lady in her courtroom, to sit there and even think about detaining her because, and I quote, this is what happens to little girls with daddy issues. So hence why I did that video, so that people can see there are good judges out there that so happen to be Black women that are qualified, that are intelligent, and that have the ability to remain neutral and impartial and get the job done. Those are more the type of judges that we need. We don't need judges like Shamila Williams. You're sitting on orders for months and months and months, almost 2-3 years at a time before she signs an order. Clearly, she has no interest in doing the right thing. And I hope when they remove her from the bench that they take her staff with her, because they enabled that nonsense as opposed to them speaking up. They enabled it. This is why I've asked many other YouTubers, please cover this judge. A corrupt judge is a corrupt judge. I understand it. I'm multitasking and covering, 2 and 3 stories at once here. The twins in Georgia. I mean, there's so much to talk about, So I've made that request, and hopefully this information gets shared, and the inner dealings of Judge Shamila Williams will be reported on more. More attention will be brought to that. She has the ability to sign orders that affect, she's a family court judge. So of course she's going to affect the lives and livelihoods of children when it comes to custody matters, child support, and all of that. The last thing you need to be is biased when you're talking about making decisions that will affect the child's life. So her ass needs to go. Bottom line, Courtneyville, make sure you go in there and get Ashley Merchant. Y'all take her down in epic fashion. We're here for it. All right. Thank you all for tuning in. Hit the like button, become a member, because this video is going straight to the members after its premiere. I'm not downloading a 2-hour video. I'm just going to premiere it and put it up there. So make sure you become a member. Consider that membership today. We have $2.99, $4.99 levels. I appreciate you all tuning in once again. Thank you so much for the support. And until the next one, Lady Luck out. Deuces.